So over the last couple of decades, I've lectured a little bit on asset protection. And one of the subjects we talk about is partnership agreements and shareholder agreements. For shareholder agreements, or the importance of shareholder agreements primarily is to put an infrastructure in place in order that a business or a company can be managed in the event of certain circumstances. That may be the management of the day-to-day, the sort of control, who has responsibility for what they can spend, and how shareholders may earn out of the business. But also, shareholders agreement can deal with shareholders falling out. So they may have arbitration clauses, so they can resolve disputes, with that comes a certain mechanism normally that shareholders can buy other shareholders out or can be bought out from the company. So shareholders agreements can manage that process where there are unfortunate falling outs between other shareholders in order that they can exit the business. Also, they can manage a process where the company is to be sold. For example, if a company is to be sold, a shareholders agreement can offer protection for minority shareholders through something called tag-along clauses, which enables a minority shareholder to tag onto the majority shareholder in a share sale, and similarly drag-along clauses, which means that the majority of shareholders can actually force or control the sale of shares in the event that the majority of shareholders agree that that is the right thing to do, i.e. sell the shares to a purchaser. Shareholders agreements can also act in a number of other ways. They can control the transfer of shares, they can link share ownership to employment. For example, when you set the company up, shareholders may say, well, we're going to put a lot of sweat equity in and time equity and stuff like that, so it links it to the role they're doing, and in the event they cease to do that role, then or perform their duties as they would for an employee, then those shares could be acquired by the other shareholder in a pre-agreed mechanism, in other words, allowing shareholders to exit or be exited in a manner that's agreed up front before any falling outs in place. Obviously, shareholders agreements, when a button is pushed to act or something within those agreements, falling outs can still occur, so there will normally be some sort of arbitration clause in those agreements appointing an independent person to help them agree either the value of shares or how the transaction will go through, or a mechanism which the transaction can be forced through. So shareholders agreements are very important. If they're entered in earlier on, they stand a good stead of showing how the company is operating in a very professional and business-like manner.